Good morning and welcome to NCAS Live. We are joined by the wonderful Philip Day of Laceys Solicitors this morning, and he is an expert on licensing. The reason we are doing a licensing special for the NCAS webinar, obviously, is that a lot of you guys are mobile caterers and currently don't have anywhere to trade. And we're getting a lot of questions from people saying, how do I go about trading? How do I stay in business? How do I earn a living when I don't have a restaurant to trade from or a set piece of land to trade from? So we called on Phil. He's been in the game a very long time. He's going to tell you a little bit about himself, obviously, but he's been working in the licensing game. He's worked in the festival sphere, in the high streets, and the licensing that's required there, bars, pubs, strip clubs, I imagine, and various other different things. And he works with the NOEA. He's worked with many great partner organisations of ours, and he's helped us several times this summer when we've had members who've had concerns or issues with licensing departments or trying to get their street trading up and running. So obviously, being a solicitor, time is money, and so we're gonna crack straight on. And I'm going to introduce Phil in a moment, but the key things that we're looking at here, and I want to be absolutely clear about this, is we're looking to help you to find a way to trade, but you can only trade if you can trade safely. So that means COVID safe. That means getting all of the stuff in place via your risk assessments, via your analysis of your business and where those hazards are, and get all your mitigation measures in place. If you can't trade safely, you can't trade. On top of that, the last week or so, we've had the introduction of tiers for the COVID response, which has caused all kinds of confusion at times. But it also means that advice that Phil can give will not be specific to the town, street, borough that you live in. He'll only be able to give general advice about how the law works, or the intent behind the law, rather than saying, can you work on this bit of land in Liverpool or Manchester or London or wherever it may be. So, but we are going to be taking questions, so please do fire the questions in via Facebook, YouTube, and the other methods. But we're going to crack on straight away. Phil, how are you doing this morning?
I'm absolutely fine. It's a pleasure to be here, and thank you very much for inviting me.
Fantastic. I mean, you've been very busy recently with regards to licensing in the event sphere. Is there much you can tell us about what happened with this big event? I don't know how much you can tell us, actually.
Yes, I've been involved with a number of issues where events have been, in one pretty drastic case, closed down literally hours before it was due to start. And there's no secret about which event we're talking about. That's the boat show. That we've taken advice from leading counsel, a chap called Philip Colvin, who has taken the view that what happened there shouldn't have happened. I won't put any further than that. And a pre-action protocol letter has gone off to the council, and their response is awaited. Where that goes remains to be seen. I've been involved with various other events where we haven't been able to help because the council have basically pulled the plug on the very simple basis of saying, you want to use our land, we're not comfortable with that, we're not giving you permission, end of. There are others that have been, they've been much more helpful working with the venue concerned and coming up with a set of rules and set of protocols, particularly in the last few days. The venue is situated in central England. It does attract people for their regular events from all over the country. So we now have different regimes as to how to cope with people coming from tier 3 who are basically being told, sorry, you can't come, your ticket's been cancelled. Those from tier 2 have been advised not to travel, and then everybody else with different rules for Wales, where at the moment you're basically not allowed to sneeze, and central belt of Scotland, where my daughter lives, and she's not allowed to go to pubs at the moment, except that changes, I think, from 8 o'clock tonight. and provided that she has a full meal. It is a bit of a nightmare.
Yeah, absolutely. And I think these are really sort of key developments for us. And when you mentioned to me yesterday the idea about people not being able to travel from different tiers, that was a kind of level of issues that I hadn't considered up until you mentioned it. But yeah, I mean, now if you're looking to promote an event, you know, it would have been, you know, I'm promoting to everyone that can access my adverts, that can, you know, that are on my network. And now it's a case of, well, I can put on an event to people within a specific area, within a specific tier, and it's getting more and more tricky. The other side of it, obviously, is that with a show like the boat show, people have lost tens, hundreds, maybe millions of thousands, no, hundreds of thousands, maybe millions of pounds on that, I would imagine. And that's going to really knock the confidence of event organisers and promoters in terms of working with local authorities to work on their land, but also just in terms of, do we have the confidence to put on an event that could get pulled at the last minute? So I think this webinar is you know, quite pertinent at the moment, because if events aren't coming back in the short term or maybe the medium term, then actually being able to trade somewhere will hopefully offer some salvation to some of our customers, really. Now, one of the big things that came out a couple of weeks ago was substantial meals, and we've had a pub company have contacted us, and we've started putting caterers into pubs in tier 3. We've already started to have some pushback from some local authorities. Phil, what do you make of this substantial meal, and how would that work? How would a trader you know, be able to provide a substantial meal, and would that offer them the opportunity to trade?
The concept of a substantial meal has been around for a very long time. Under the old licensing regime, going back to the 1964 Act, there were different categories of license, on licenses, off licenses, and then restaurant licenses and residential. And for a restaurant license, the sale of alcohol had to be ancillary to the provision of substantial refreshment, in other words, a substantial meal. No one has ever been able to actually define precisely what's meant by a substantial meal, but the general understanding of it is that it would be something that you would normally sit down with a plate, knife and fork, and eat it with knife and fork. There's been one example recently of a pub who partnered up with a pizza place across the road, and ordered a whole pile of 20-inch pizzas, and then basically said to people coming in, sit down at your table, order your drink, and here's your substantial meal, being a slice of the 20-inch pizza. That's really arguable. Things like that will keep the lawyers going for a very long time. It is certainly the case that if you give somebody a pack of crisps, bowl of peanuts, that is not a substantial meal. If, on the other hand, you give them, you know, Sunday lunch, roast beef, whatever, with the potatoes, parsnips, peas, vegetables, pudding, apple pie, soup to begin with, that is most definitely a substantial meal. But the other thing that you've got to remember is that the alcohol has got to go with the meal. So you can't go in, have your meal, and still be in the pub 5 hours later on your 12th pint of Guinness or whatever it is.
Okay, so taster menus with wine flights the way to go.
Yeah, I think at the end of the day, there has to be an element of common sense here. And if in doubt about what your local council might regard as a substantial meal, the best thing is to go and ask them in advance, and try and reach an agreement with them, rather than trying to, you know, take the Michael, as it were, and pray and hope and argue about it after the event. If you get agreement in advance, then you ought to be pretty safe.
But it does an opportunity really for caterers who aren't able to trade, don't have somewhere to trade, in that they can kind of buddy up with a local pub or other type business and provide that meal almost as a subcontractor. So if a pub in tier 3 has to shut because it can't operate as a restaurant, then we've had it confirmed by government that, you know, our caterers can go in there operate under the licensing essentially of the pub. They become a subcontractor.
Yes.
Yeah. So as long as you, I think it's about, you know, follow the spirit of the rules, not just the letter. You know, because the last thing you want to do is get all of this in place, and a week later the local authorities turn up and say that's not a substantial meal. You're all shut down. You can all go home. You know, what we achieve there. So I think that, yeah, as Phil was saying, the spirit of the law is essential here, and you know, staying in contact with your
there is one thing that overrides all of this, again, different rules apply in Scotland and in Wales. So I'm only talking about England, but there's been so many different regulations. It's not true, but probably the most important single one out of the whole lot is this thing, which is, if you can see that, it's the Public Health England Health Protection Coronavirus Restrictions England #3 regulations 2020. And what this does is it gives the local authority, and the local authority here is the county council. If you've got, I mean, I live in Hampshire, we've got a town council, we've got New Forest District Council, and then on top of that, Hampshire County Council. It's Hampshire County Council that has that power, not either of the lower authorities. And what this allows them to do is to give a direction if they consider that giving this instruction or direction responds to a serious and imminent threat to public health, that is necessary for the purposes of preventing, protecting against, controlling, or providing a public health response to the incidence or spread of infection by coronavirus in the local authority's area. They can't say there is a problem in England generally. There needs to be an issue in that area, and that the prohibitions, requirements, or restrictions imposed in the direction are a proportionate means of achieving that purpose. And in other cases, that's what the argument is about. But these are quite lengthy regulations. But what it does allow is for the local authority to close down individual premises. They can do that. They can close down or prevent individual events from going ahead. And they can also close down public outdoor places. A complete close down is the sort of ultimate sanction, but they can also do various other things. They can restrict entry to the premises. So they could, for example, turn around and say, you can only have 10 people in here, guys. You have any more, it's going to cause a risk. They can secure restrictions in relation to the location of persons in the premises. So, yeah, you can use the beer garden, but you can't use the snug. It's too small, or whatever it is. But they can also reach an agreement with you, and that's what's been happening with one particular case that I've been dealing with. They've reached an agreement with regard to various protocols about security, spacing, checking people as where they come from, taking temperature. There's a lot of debate about that one. I think the general consensus is that that's not actually very helpful, because taking somebody's temperature isn't going to detect whether or not they've got COVID and things like that. So that overrides absolutely everything. So even if you tick all of the other boxes, and we'll talk about those other boxes in a minute, there is always the risk that the county council or the unitary authority or the city council or whatever will come along and say to you, coronavirus regulations, we think there's a major problem with regard to this, we're going to stop it. And they can do that. There are rights of appeal, but in practical terms, those rights are pretty useless. One of them is to a magistrate's court. You get a hearing in a magistrate's court in time to save your event is going to be a bit of a miracle. You can also appeal to the Secretary of State, but experience to date suggests that the Secretary of State is probably going to back whatever the local authority have decided to do.
Yeah, otherwise you'd be on the wrong side of a court case or a legal action. You know, basically making them liable potentially. So yeah, I don't imagine that too many Secretaries of State would be supporting the event organisers there. We've obviously discussed you there are different ways of trading. But before we go on to that, I just want to clarify a few bits on the tier 3 pubs. Our recommendation is, we're expecting mobile caterers and potentially function caterers to take up these opportunities. Function caterers, your wedding caterers, things like that. You'd imagine that they would be working from the on-site kitchen, in which case you've got to tell your local authority that you're working from a new kitchen. That's an EHO thing rather than planning or licensing. With that in mind, if you've got a trailer or a unit and you are looking to go into a pub, I would take that there, because then you don't need to get a new hygiene inspection for their kitchen, because you brought your own kitchen with you. The other thing is, in order to be within the spirit of the law, the money should be taken by the pub on your behalf, and then the order comes to you, and then you arrange your way with the pub for that food to get taken to the customer. But essentially, they do the table service, they take the money, you are subcontracted to them, and that way that you're happily working under their premises and under their license. The other thing with that is you could also operate as a takeaway and delivery option, click and collect, in addition to working as the restaurant on behalf of the pub. So there are real opportunities there. There's more and more parts of the UK move into tier 3. More and more wet-led pubs are either going to have to find a way to operate as restaurants or to shut down. So I've had a little question. Would if someone's working under the premises of a pub, so under the pub's alcohol license, under the pub's premises license, would they need a street trading license or anything like that, Phil, to provide that subcontracted restaurant?
Okay, street trading is a different regime. And there are different rules again that apply in Scotland, Wales, Northern Ireland and England. And within England, there is a slightly different regime that applies in Greater London. The powers under it's actually the Local Government Miscellaneous Provisions Act 1982. And what that allows a district council this time, so in my part of the world, that wouldn't be Hampshire County, that would be New Forest District Council or a unitary authority or a city council, but not a town or parish council. They can resolve to effectively apply these rules. And what it allows them to do is to do one of three things. They can designate a particular street, and I'll come back to the definition of street in a minute, in which street trading is prohibited, full stop. You can't do it, end of. They can then have licensed streets, where it's a street in which street trading is prohibited without a license. So you have to apply for a license. And then there is a subtle difference that you can also have areas which are designated as a consent street, which is a street in which street trading is prohibited without the consent of the district council. And the differences between the license and the consent are in some respects rather subtle. But with regard to a consent street, not only do you need to get consent to trade there, but if you have a van or a mobile unit or something like that, you have to get specific consent, not only to be able to trade, but also to be able to take your van or whatever there. The important thing here is the definition of a street, because it isn't just a street as you or I would understand it in normal parlance. It includes any road, footway, beach or other area to which the public have access without payment, and a service area. So it's generally any space where the public are free to go. Now, there is an argument about pub car parks, because some local authorities are saying, well, any member of the public can drive into there, it's a public place and so on and so forth. Well, yes, it may be a public house, but the landlord always has power to say to somebody, no, you can't come in. But the point is that unless it's been designated in one way or another, then the requirement to get a street trading license or a street trading consent doesn't exist. So the first thing that you need to do is to check as to whether or not the local authority has designated the area in which you want to trade as a prohibited area, in which case, forget it, you can't do it, period. A licensed street in which you can, but you've got to get a license from them, or a consent street where you've got to ask for their consent. Now, there is one subtle difference in London, which by the sound of things, some local authority officers seem to think has general applicability, but it doesn't. And that is that in London, the definition is different and includes, and I quote, any other area not being within permanently enclosed premises within 7 meters of any road or footway to which the public obtain access without payment. So if you're in London and you've got a restriction on a street, you've got a long driveway and you want to park your catering van in the driveway and sell from there, if it's within 7 meters, you can't. Now, part of the problem with all of this, and probably the best example I can give you is driving a car, because we're all familiar with this. If you're driving a car, you need a driving license. But the car also needs to be taxed, it needs to be MOT'd, and it needs to be insured. It is no good when you get pulled by the police saying, yeah, but I've got an MOT, I've got a tax disc, and I've got a driving license, so I'm okay, but you haven't got insurance. And exactly the same applies to this sort of thing. You need to make sure that you comply with all the food hygiene regulations, that you've registered as food premises if that's appropriate, and that you also have planning consent. And in terms of street trading, yes, if there is an area that has not been designated, you can take your van there and you can sell in the street from there, provided you tick all those other boxes. But you've also got to make sure that you're complying with traffic regulations, that you're not in a no waiting or no stopping zone, and that you're not causing an obstruction to the highway. So that's the starting point. There are various exemptions, one of which is a peddler. If you're a peddler, then you need a license, but you don't get that from the council, you get it from the police. But a peddler is basically a one-man band or a one-woman band who walks the streets trying to sell their goods, which would be small items which they are carrying around with them. They are allowed to have something small to assist them in carrying their goods, but the point is that they're on the move all the time. And again, you need to be a bit careful because rules in London are slightly different. Sorry, excuse me, I've got phone ringing. Right, got rid of that. There is the exception for peddlers. There are various other things which aren't really going to apply to your guys, Mark. You can sell newspapers and you can do things like that. But there's also this concept of roundsman. What's a roundsman? Well, I've got 2-3 here. One of them delivers my milk. That's perfectly permitted. They are doing the rounds, literally, which is why they're called roundsmen. A postman is a roundsman, delivering letters, parcels, and so on and so forth. And there is nothing to prevent a caterer from having a roundsman to go and deliver their meals, whatever it is, from their mobile unit or from a pub or restaurant or anything like that. And that is all perfectly legitimate. They've changed the law with regard to unlicensed premises, that if you're concerned with alcohol and your license only permits you to sell alcohol for consumption on the premises, which is often the case for restaurants, they have changed the law so that until the end of September next year, you are allowed to sell alcohol for consumption off the premises, and all you have to do is to display a notice saying that you're using this power. There are a few exceptions. So, for example, if somebody's applied for an off license and been refused within 3 years, then they can't use that exemption. So, although there is no requirement to tell the council this is what you're proposing to do, it is a good idea to go to them and say, this is what I'm proposing to do. There isn't any reason why I shouldn't, is there? And 9 times out of 10, there won't be a reason not to. Sorry, somebody I think is asking, what do you mean by street trading? Well, the answer basically is selling goods in the street. It's as simple and as straightforward as that. Whether you're doing that from a stall, whether you're doing it from a barrow, whether you're doing it from a mobile unit or whatever. Can I also, part of the problem with all of this is that there are so many exemptions and different things. There are established markets, charter markets. Where I live in the edge of the New Forest, we have a charter market that dates back centuries. Those attending on the Wednesday charter market, they don't need a street trading license because they are there at the behest of the charter market holder, who in our case is the, God knows how many generations down, but a direct descendant of the original charter holder, who was and still is the local lord of the manor, and so on. But it's basically selling anything in the street.
Yeah, and I think that, also there's the questions in terms of subcontracting by a pub. I think this is become quite a grey area, and I think that the rule of thumb is to follow the letter of the spirit of the law. So if you are trading from a pub and you're describing yourself, or you're acting as a subcontractor, and you're essentially providing a catering service into another business who's then selling that service, then if they are taking the money, if they are doing the serving, and you are doing the catering, then you shouldn't need a license, because you're basically acting as the kitchen of the pub. It's only if you are, well, whether you need a license will come down to the things that Phil was talking about a moment ago in terms of consent and things like that. But if you're working under the premises of another business, then you shouldn't need a separate license for that.
No, if you are supplying a pub or a restaurant with food which they are then onward selling to their customers, then there is no element of street trading there. If you're doing it from your bakery or whatever it is, or you own a pizza parlor or a fish and chip shop or whatever, and you are taking your fish and chips or pizza over to the pub and handing it to them, that doesn't come. I mean, you may have walked the street to get from A to B, but that's not street trading. It's actually selling on the street. That is street trading. It's really simple as that.
So if I went into a pub and there was a mobile caterer outside, and I bought the food from the mobile caterer from the pub, so I went up to the till, said I'd like a pint of whatever and a portion of whatever, that's not street trading. But
right, hang on, wait. Right. It depends on, you don't have carte blanche to take your burger van or whatever and park it outside a pub, and then take the burgers into the pub, because arguably that is street trading. Now, if you can park your burger van in the pub car park and walk the burgers into the pub from there, then there is this argument about whether it's a public open space. But the starting point is to check whether or not it is within a prohibited area, whether it's in a licensed area or a consent area or no area at all. And if it's not covered by any area at all, yeah, of course you can go and put your van in the pub car park. You need to be a little bit careful about planning consent, because if you are going to be there for any period of time, it used to be a month, it's now 2 months, then you need planning consent for change of use of the land. And if you're going to build anything that is permanent, then again, you need planning consent. Come across one case in a rather different context where somebody's built a very large shed, but put it on a huge pair of skis on the basis that he can supposedly tow it around his field, and is arguing currently successfully that he doesn't need planning permission for that. But you know, again, you need to be a little bit careful that you're ticking all of the boxes, including planning. Just mention one other thing as well. If you are selling hot food and drink after 11 o'clock at night, then you need a premises license under the Licensing Act for that. Bit academic at the moment, but if you are doing some business, you're taking orders over the telephone or whatever, and you are delivering your pizzas or burgers or whatever they are to people at home, and you're doing that after 11 o'clock at night, you need a license under the Licensing Act as well. Of course, academic as far as the pubs are concerned at the moment, because they all have to shut at 10 o'clock anyway.
There's possibly, maybe I'm being a little bit cheeky, but I may have noticed a little workaround potentially. You said 28 days, it's been extended to 56 days when you don't require planning permission. Would that mean that if someone took a unit to somewhere where there was no requirement for consent, it wasn't prohibited, it wasn't licensed street, they complied with all the rules, could they trade there for, say, 3 weeks without planning permission? Or would they have to apply for planning permission? Or
it depends to an extent on how they're actually doing it. I mean, if they're driving a van in, and it's there, you know, during the opening hours of the pub or whatever it is, and then it goes away every night, then that arguably doesn't need planning at all. It's if you have a permanent or an intended permanent change of use of the land, that's where it wanders into planning. I confess that there is an overlap between planning and licensing. I'm not a planning expert, and if in doubt, then seek advice from a properly qualified planning consultant.
I mean, that was the 56 days. We asked the government for money for our customers, and they just doubled the 28 days for us. But we got something. But that is potentially a way that people can trade. So, you know, if you are looking into that, we had a customer, still have a customer, who many moons ago, quite an infamous customer who was running a burger van in Peckham, and every 27 days he would move the van to a different car parking space in the car park that he was in, and caused all kinds of consternation at the local authority, and a lovely time doing it. But so that 28-day rule is something that can potentially facilitate street trading, because obviously the planning takes 3 months and is never guaranteed. So this could be a way of getting out trading potentially if you get everything else in place. Would you say?
Yes, I mean, you know, the government has done various things supposedly to help pubs and restaurants. Somewhat akin to street trading is a thing called a pavement cafe license, or a table and chair license. Different local authorities call it different things. But basically, if you've got a pub or a restaurant and you want to put tables and chairs outside on the pavement, then you are committing an offence under the Highways Act of obstructing a highway because the pavement forms part of the highway. But you can make an application to your local council highway authority, that would normally be the district council, for permission to put the tables and chairs out there. One of the things the government did a few months ago was that they changed the law. They required local authorities to deal with applications for these table and chair licenses within 14 days. They also capped the fee that the local authority could charge to £100, which in some cases was very substantially less than what they were normally charging, and so They haven't done anything similar to facilitate applications for street trading licenses or street trading consents. And that might be an area that you could perhaps try lobbying. You know, you've done it for the pubs and restaurants. Why can't you, well, and cafes as well, you know, non-licensed, non-alcohol licensed premises. Why can't you do something similar with regard to street trading? I mean, you know, the going rate, it varies across the country, but, you know, 750 quid a time or something like that. If they could be persuaded to cap the charge at, say, £100, it might make all the difference between something that's viable and something that simply isn't.
Yeah, we're pushing back on street trading licensing as much as we can, as much because of the fees as anything else. We've had a lot of traders in Cambridgeshire have been sent bills for £850. We've had, yeah, a lot of people starting to get bills recently, and what we're doing is questioning them, and I think that that's part of why Phil's here today, just to make sure that the council know what they're asking for and what they're charging for, because we're not sure they always are, and also that what they're charging for is actually appropriate for the situation. And I think the issues around consent and the issues around planning definitely give our members some scope to get arrangements in place that are both safe and legal and enable them to trade.
Can I just mention one other thing? You mentioned fees. If you make an application for a street trading license, although the council has a discretion as to whether or not to grant it, that discretion is limited, and there are limited grounds upon which they can do it. The first is they cannot grant a license to somebody who's under 17 rather than 18. Why 17? Past, don't know. Ask your MP who voted for that. They have a discretion to refuse to grant the license on the grounds of a lack of space. They also have a discretion to grant it, to refuse it on the grounds that there are enough traders or shops trading in the same goods in the area. They can also refuse to grant it if you basically have a history of not paying for earlier street trading licenses, and if you have convictions. The license has to specify what sort of goods it is that you're going to sell, and which streets you're going to sell it, what days, and during what times as well. And they do have power to revoke licenses. They also have the power, for example, to change their mind and say, well, this was a consent street or it was a licensed street. We've now decided that we don't want that anymore. It should be a prohibited street. And they can do that even if people have been trading there for yonks. But somebody's asked a question of the 28, 56 days consecutive days or within a year. The answer is it's within a year. You can't do one batch and then have a couple of days off and then another batch, a couple of days off. It's cumulative rather than consecutive.
And that's for the business, you say? Sorry,
I didn't catch that, Mark.
Would that be for the site rather than the business? So I can only be on this one site for 28 days, or a business?
No, it's the place that we're talking about. Planning goes with the location. You can't get planning permission for a marquee and move it around in exactly the same way. If you've got a mobile bar, for example, you cannot license the vehicle and then take it wherever you like. You have to get an authorization, which is normally a temporary event notice, wherever the van, whatever it is, mobile bar, is actually parked up, situated. And again, on temporary event notices, there are restrictions as to how long they can last and how many days are covered for any particular place. But with that one, your little wheeze with the chap using different bays in the car park does actually work with temporary event notices, because you can give a temporary event notice for that bay, and then you can give another one for that bay because it is defined as being a different place. What you can't do is give a temporary event notice for the van and then take it around whatever you like.
Okay, and that's really helpful, I think, for a lot of our guys. And I think the temporary events notices, some of the event organisers I've spoken to over the years with their, you know, we've got 10 different temporary events notices, all my 10 different bars across the site. Always made me smile. But
my record is 28. Well, it's actually 28 temporary event notices and 10 premises licenses for different marquees and so on and so forth, and that works true.
If it makes sense, it makes sense. You know, it works for me. And one of the things that we've been looking into is what I call sort of an Englishman's castle. You know, can people trade from their driveways, from their home? I think I saw a guy in London this week pop on social media and then disappeared pretty much immediately. But it's up a Negroni bar on his driveway. Which
he's got a problem in London because the 7-meter rule applies. And you know, if it's a designated street that he lives on, then even if he's on his own driveway, he's got to be at least 7 meters away from the street, and that includes the pavement. You can't ignore the width of the pavement. You've got to go back a further 7 meters, which is then going to make it a bit difficult, and so on and so forth.
Would you be able to put a gate on your driveway and say that you're only permitted in if you're buying Negronis? That account would just tell us that it was still.
You could charge them. I mean, it's without you can't obtain access without payment. There's nothing that says how much you can charge them. So I've decided I'm going to charge you a penny, or something like that. And everything I've got is priced at something 99. So you pay me the penny when you buy your whatever it is, and it costs £1. Yeah.
We did actually. We had a trader who did that in Peterborough many years ago. Her husband owned like a builder's yard, and so she put a burger van out the front to sort of sell burgers and bacon butties to the builders coming in to get their stuff. And she got pulled up for a street trading license. She literally charged everyone a penny to walk onto the builder's yard. And I think she fell out with the council pretty quickly with that one. But there are kind of ways around it, essentially. So worth looking into. But one of the things that I'm getting from this, Phil, is that these things seem much more negotiable than I've got the impression in the past, and some of my customers have the impression of, you know, is it worth negotiating or discussing these things with your local authority? Yeah. So rather than just.
Well, Mark, we're running out of time, and I don't really want to interrupt you, but there are a couple of questions that I think we can answer fairly quickly. The first one was somebody, Zoe, wants to know rough idea how long it usually takes to obtain a license to sell coffee from a trailer at the side of the road. It does vary hugely, but realistically unlikely to be less than 3 or 4 weeks. Normally that would be the case. With some local authorities, it's going to be a lot longer at the moment because so many people are working from home, and things like this are not getting the highest priority. Second question from Damien: is it legal to give away an alcoholic drink free without a license on a food stall? So buy a pizza, get a beer free. We're trying to entice custom and pondering this. The answer to that is that it is the sale of alcohol that is a licensable activity. If you come round to my house, I'm at perfect liberty to give you an alcoholic drink at my expense. Don't need a license for that, but if I'm going to charge you for doing it, then I need to do it. The classic problem with this, funnily enough, was Parent Teachers Association doing cheese and wine evenings, and charging a £5 for the cheese, and you get a free glass of wine. No, you don't, because there's no way that the cheese is going to cost a £5. It's included within the price. You are selling it. If you are genuinely giving away drink, genuinely giving it away, then in those circumstances you do not need a license. But you can get into all sorts of messes and everything else. You know, you only get it free if you buy a pizza no, sorry, that's not free, because there is a condition that you've got to give me money, which you've dressed up as something else. Then there's another one.
What I'd add to that is, why would you give away free booze? It's crazy. You know, so your food will sell. Your food will sell. Drink the booze yourself. Save that till afterwards and drink that yourself. The one last thing that I was hoping to get a bit of clarification on, Phil, was the difference between public land and private land. Obviously, we covered at the start that the local authority have the capacity to shut you down regardless of where you're trading if the conditions require it. But would you say that it's easier to get to trade from private land or from public land?
But it's definitely easier to trade from private land. You know, the minute you're on public land, quite apart from anything else, you're going to need the consent of the public authority to be there. And you know, that's what has happened with various events. The length and breadth of the country, the council hasn't deemed it necessary to serve a notice under the coronavirus regulations. They've simply turned around and said, this is our land, you can't use it. I mean, wearing a different hat, and I think I can help Cindy with this one. Wearing a different hat, I actually also am an event organizer for my local town council. We generally every year do a fireworks display. We were going to do VJ Day, having cancelled VE Day celebrations, and at Christmas we usually have a big light switch on and everything else, and a market. Certainly my view with regard to the market was that, given that we have here a charter market every Wednesday, that there was no reason why we couldn't have a Christmas market, and that would be organised by the town council. I didn't see a problem with that. The shops are open. It would have been on a Sunday when all the shops were closed. There was a slight issue as to whether or not we'd actually managed to get a road closure through in order for us to be able to safely, you know, put stalls in the middle of the road. That's again quite different from street trading. We didn't need street trading license because there is nothing under this legislation that applies in the particular location that we were proposing to use. However, a majority of the councillors were not comfortable with it because they felt that with so many markets being cancelled, if we were to do it, it would bring in people from a wide area, that there may well be issues of social distancing and all the rest of it. So they decided to pull the plug on it. I have a nasty, horrible feeling that Christmas markets, you organise one and spend money one at your peril at the moment, because personally I think that town councils, district councils, county councils are very nervous about things like that, even where there is an established market, and for one reason or another they may refuse you consent, you know, particularly if you need a road closure. That is not something that you can insist on, for example.
I think we had a really interesting question by Cindy Barron, who's runs a mobile bar, about running a mobile bar at a market in Tier 3. It wouldn't be a bar, it'd be an off license. Am I right? Would they be able to sell us off sale, or would they not be able to sell at all? Or, I mean, assuming the market could even go ahead in Tier 3, which we just mentioned that there may be.
If the difficulty with mobile bars at Christmas markets is that what you're actually tending to do is to pour a pint, and there it is, and people drink it. Now, that basically isn't allowed. What you're going to need to do is you're going to have to provide tables and chairs, make them sit down, and it's got to be ancillary to food. If you are genuinely doing it as takeaway only, you know, cans, sealed containers, whatever, then that is permissible. But the minute the people start opening up and drinking in the vicinity of your mobile bar, then you've got a problem. there shouldn't be any grounds to refuse a temporary event notice, because the various authorities, one of the licensing objectives is public safety. Although the health authority is a statutory consultee on licensing applications, public health is not a licensing objective. So you should not be refused a temporary event notice because of concerns about public health, because it's not on the list of licensing objectives. It's public safety. There are some local authorities that have been dressing that up a bit, but if a push comes to a shove, they can go back to this thing, and they can serve a direction on you at very, very, very short notice, even halfway through the market, saying close down. And that, as we said right at the very, very beginning of all of this, is a risk that anybody and everybody is taking if the county council, in that case, considers that there is a serious and imminent threat to public health. Then they can issue these directions in order to, as a response to the incidence or spread of infection in the local authority's area. And if that happens, you're pretty well shafted, forgive the language, but that is the case.
Yeah. I think we're running out of time. It's been brilliant, Phil. Thank you so much. I mean, it's been really, really helpful for me, and no doubt for loads of our customers. I'm sure they've got loads and loads and loads of questions, and if you guys fire them in, we'll try and get them answered on social media and things like that. Obviously, Phil is available as a licensing expert, lawyer, solicitor. I don't know how the exact terminology, but he's an expert, and if you are having problems, you can give him a call. Obviously, he's not free, but he's very helpful, and if you do have a specific issue, he's been really helpful for us, and I'm sure he'll be working with us for years to come, hopefully. But yes, hopefully this will give you guys some insight into what street trading could look like, or to go out and trade. Street trading is probably the wrong phrase to use, but there should be some options in there that a lot of you can work with. Obviously, stay safe, stay within the spirit of the law, stay within the letter of the law. As Phil has been mentioning, these COVID regulations will supersede anything. So if anyone thinks that you are acting inappropriately, you're just going to get shut down. You can get fines, get all kinds of problems. So if it can't be done safely, don't do it. Don't take a risk you can't afford to take, either in terms of your health or financially or legally. But there are options there for you. And I just want to, Phil, thank you so much. It's been really helpful.
Can I just take the opportunity for one little plug? You mentioned earlier that I've been involved with the National Outdoor Event Association, or NOAA, for more years than I care to remember, actually. This year, we've had to cancel our usual convention and awards dinner and everything else. But we're going to be online on the Monday, Wednesday and Friday of the week commencing the 16th of November. Anybody who is interested in coming along, please visit the NOAA website, www.noea.org.uk, and you can get details of the convention there. Basically, all are welcome. We're not charging for it either. So there you go. Anyway, thank you very much for your time. Thank you for the invitation, Mark. It's been a pleasure.
Brilliant. Cheers.
Right. Cheers. Take care, everybody.